in the Constitution, Section 25(2), that makes provision for expropriation. So therefore, you are only focusing on Section 25(7), but you are overlooking the fact that both Section 25(1) and 25(2) of the Constitution talks to the provision for expropriation to take place. Then what is your say in regard to that?
Thank you, Chairperson. It's important highlights, but what we must then agree, Chairperson, is that if a committee of Parliament or any institution is granted that right to expropriate land, whether it's with or without compensation, and it violates the Constitution, are we not coming back there at the same address, at the same place, that we cannot violate the Constitution, even though we say it's in the public interest? And the question is then, to what extent does the public interest apply? Are we saying then here today, if I listen to you correctly, Chairperson, are we saying then that this expropriation bill will have enough power to expropriate land beyond 1913 and factor in that land that was lost before 1913? If that's what we are saying, then we have a conversation. But in the absence of that, if this legislation does not do that, then we are again at the same place where we're saying that the legislation does not have enough power to correct that which was wrong, and therefore then we will have to come to a place where we say we have to change the Constitution if we are going to allow for the African majority, which is the Sandakoi and the Bantu Nguni people, to enjoy the land which they have enjoyed before anybody else came to settle on the land. But we have to deal with this elephant in the room, Chairperson. So if this legislation is going to do that, then we're going to have a very good conversation, and we could possibly even support the legislation. But in the absence of that, if it doesn't do that, we cannot support this legislation. I thank you.
Thank you, Mr. Williams. Again, let me, on behalf of the committee, extend a word of gratitude and appreciation to you for honoring our invite. And indeed, we have learned a lot from your presentation. Thank you. Have a wonderful day. We will now proceed. Thank you. We will now proceed to the third presenter. The third presentation will be made by the Center for Social Justice. Advocate Madonsela will be leading the presentation on behalf of the Center for Social Justice. Over to you, Advocate.
Thank you, Honorable Chairperson, esteemed and honorable members of Parliament. On behalf of the Center for Social Justice at Stellenbosch University, I thank you for the privilege to present a compacted version of the submission we made on the expropriation bill in March this year. Firstly, I do want to indicate that we support the initiative, the idea of having a bill of this nature. We support the idea of having a bill of this nature primarily because our law on expropriation is antiquated. It's a 1975 bill, number one. The second reason our law is inappropriate for our time is the fact that that law was passed at a time when expropriation was part of the weaponry that the South African government had to dispossess the people of this country. And you will recall that 1975 specifically comes at a time when the country was implementing the apartheid laws that had come into play since the National Party won power in 1948. And therefore, anything that came during that period was not meant to be good. And with the advent of our Constitution, we needed new tools to give birth to the new Constitution that South Africa had accepted. So the Law Trust Chair, which is now the Center for Social Justice at Stellenbosch University, sees resonance between what is being done and our work. As a center, we exist in order to assist those in power to pass laws that are aligned with the Constitution, to pass laws that are conscious of social justice imperatives, and to provide tools for assessing these laws even before they are passed, to ensure that they don't have the unintended impact of exacerbating social justice. We see this bill as having the opportunity.
My apology, Advocate.
Yes.
Do you have the sharing rights to start your presentation?
I'm trying to share. Is it not sharing, sir?
It is not, Advocate Madonsela.
Okay, let me stop sharing then and start sharing again.
Thanks.
Okay, I was sharing. Is it sharing now, sir?
Yes, we can see the presentation now. We can proceed, Advocate Madonsela.
Okay, thank you, sir. Right. So I was at a point where I was saying we see resonance between what the committee is trying to do and the work we do, because we exist for the purposes of expanding and deepening social justice research and scholarship with a view to making an impact in society, particularly regarding the social impact conscious law and policy making processes. We define social justice as equal enjoyment of all rights and freedoms by all, reflected in just, equitable, and fair distribution of all opportunities, resources, benefits, privileges, and burdens in a society, group, and between societies. We believe that in a socially just society, as envisaged in our Constitution, no group should find it easier or more onerous to exist in society. Our definition of social justice is influenced by the plasticity of the concept of justice, including social justice. And we understand that social justice has had plasticity, in other words, adaptability, since it was coined by Italian Jesuit philosopher Luigi Tapparelli in 1843, and further developed by another Italian philosopher, Antonio Rosmini, who brought together social justice with the law and the Constitution. It was adopted globally, we know, in 1919 as a solution to the conflict that led to the First World War. And it became part of the Treaty of Versailles, which was the foundation of the International Labour Organization. In 1995, it was fully discussed in the Copenhagen Declaration, and the understanding that social justice is a lens through which we view human rights from the point of view of equal enjoyment of all of those rights by all, come from the Copenhagen Declaration. Our Constitutional Court has also made it clear that social justice is not an option, it's a constitutional mandate, that when we adopted this new constitution, we sought to build a more egalitarian society that is founded on democratic values, social justice, and fundamental human rights. And in S versus Makwanyane, the Constitutional Court also told us that social justice is a dimension of Ubuntu. And as we all know, Ubuntu is about recognizing the humanity and equal worth of every person within a system and social scheme where we understand the interconnectedness of humanity. And therefore, in a socially just society, land access should be equitable because nobody invented land. It is something that was there, and it's something that belongs to all. Of course, we know that in South Africa in the past, the law was used as an instrument of land dispossession. I listened when a previous speaker spoke about land disposition through laws, but we have focused primarily through, we've focused as a center primarily on how the law was instrumentalized. So it wasn't conquest, it was the law. The whites in South Africa had not conquered the blacks. It was England, a whole country, that ruled South Africa at the beginning of the problem, around 1896, when the first law was used to dispossess, the Glen Grey Act, with a view to dispossessing blacks so that they would be less competitive in terms of agriculture, and also they would become unfree labor to supply the mines and agriculture. And of course, if you read Black and Dull, you will understand that there's a whole litany of laws that dispossessed everyone, whether they were Black, colored, and Indian. And our Constitution, therefore, lays the foundation for dismantling the inequalities that resulted from the instrumentalization of the law to dispossess. The Constitution commits to the establishment of a new egalitarian society based on democratic values, social justice, and fundamental human rights, where every citizen's potential is freed and life improved. In S versus Makwanyane, I have indicated that the Constitutional Court said there is a need for understanding but not vengeance, for reparation but not for retaliation, a need for Ubuntu but not victimization. And Madala J continues to say the concept of Ubuntu appears for the first time in the preamble, but it is a concept that permeates the Constitution generally, and more particularly Chapter 3, which embodies the entrenched fundamental human rights. The concept carries in it the ideas of humaneness, social justice, and fairness. It is with this understanding of the Constitutional Court's reading of the Constitution that we should be looking at the Expropriation Bill, looking at it, the extent to which it becomes an instrument for transforming the power relations we inherited with regard to land ownership and distribution. Section 25 specifically states that the state must take reasonable legislative and other measures within its available resources to foster conditions which enable citizens to gain access to land on an equitable basis. While Section 25(8) specifies that property protection rights in Section 25 may not impede the state's land redress measures to address past land injustices, subject to compliance with the limitation clause in Section 36 of the Constitution, and I apologize for that mistake. In Grootboom, the Constitutional Court stated the following, I quote, "The people of South Africa are committed to the attainment of social justice and the improvement of the quality of life for everyone. The preamble to our Constitution records this commitment. The Constitution declares the founding values of our society to be, quote, quotation marks, the achievement of equality and the advancement of human rights and freedom." This is in Grootboom versus the government of the Republic of South Africa. And it was a housing case, but the way the Constitutional Court dealt with this issue brought forth the intersection between access to land and access to housing. And therefore, when we deal with land, we often deal with it only in terms of its agricultural import. But land has many uses, and therefore it cuts across various aspects of life. As we deal with this bill, we should also take the words of Justice Cameron in Daniels versus Grebante to heart. He said the following: "The first and second judgments remind us all, and remind white people in particular, people like me, lawyers who grew up with the benefits, both accumulated and immediate, of their skin color, in a society that deliberately set out to privilege them. White people who are still the majority in the profession and probably still the majority readers of these reports, that the past is not done with us, that it is not past, that it will not leave us in peace until we have reckoned with its claims to justice." And Daniels versus Grebante was a land case that dealt with the rights of with Esther rights or the rights of people who live in land on the basis of leasing, rental, and related lesser land rights. We also need to bear in mind Minister of Finance versus Van Heerden, which tells us that advancing equality is not an elective thing to do. It is compulsory. It is a requirement of the Constitution. I have the full reading here, but I will skip it and then just go to Justice Ngobo in Batu Star, where he said the following: "In this fundamental way, our Constitution differs from other constitutions, which assume that all are equal, and in so doing simply entrench existing inequalities. Our apartheid legal order cannot be eliminated without positive action being taken to achieve that result. We are required to do more than that. The effects of discrimination may continue indefinitely unless there's commitment to end it." So what has happened since the Constitution was adopted in 1996 and the interim Constitution adopted in 1993, which gives us 30 years of implementing constitutional democracy? Hall and Rijeje, among others, have written prolifically on the hits and misses of land reform. focusing on restitution and redistribution since 1995. The key finding is one of policy dissonance and even ineptitude, corruption, and unconscionably prohibitive costs of purchasing land for redistribution and restitution. This finding, backed by the land report of the Presidential Advisory Panel of 1919, shows that due to regressive policy choices since 1999, land ownership disparities are now worse than they were when Sol Plaatje penned his lamentation titled Native Life in South Africa in 1914, following the 1913 Land Act. The report places African land ownership at about 4%, 4.5%, and white land ownership at over 70%. The colleague who spoke just before me raised the question of who do we call African. I use African here advisedly because he makes a very important point about why do we call others African and we don't call others African. And he is correct. I use African here simply because the law calls those who are Bantu and others African, those who are of mixed race, color, those who are of Asian descent, Indian or Asian, and those of European descent, white. But the colleague is right that this needs to be corrected. Where he is wrong is the assumption that Khoi descendants are only coloreds. We know for a fact that, for example, families such as Mandela's, Tutu, are also...
As you conclude, Advocate.
Yes. Okay. Thank you, sir. So I just wanted to say that there's just a mistake, though, to say only coloreds are of Khoi descent. Many South Africans are of Khoi descent. So let me just conclude then about what is wrong with the bill and what is right with the bill. We like the fact that the bill says that it brings a greater human rights awareness to compensation for expropriation, which was not in the 1975 bill. It also clarifies the constitutionality of nil compensation. It democratizes the administrative justice process that has to take place during expropriation. It also recognizes subjects of customary law who up until now have been worse off under the current expropriation bill. And it offers an opportunity to test implicit constitutional permission of expropriation without compensation, without changing the constitution. What is wrong with the bill? It's technical. It has a long process that is expensive and adversarial. It is not tailored for ordinary people. So chapter 4 and 5 need some rethinking to simplify the process and to make it cheaper and affordable for ordinary Gogodlaminis. We speak in the submission about, for example, people who have had their land taken away by chiefs, and we've had people who have had their land expropriated by government, or portion of it expropriated by government, the Peter sisters and the Dlamini family being customary law land and Peters being ordinary land. And they were not compensated. And because they didn't have money, they were not able to deal with these challenges. And this bill doesn't resolve them. Group rights, particularly communal land rights, need better accommodation. We need clearer compensation parameters. And the bill could have a negative impact on investment, not just foreign direct investment. It could have negative implications for food security, simply because it doesn't fully clarify how the decisions will be made around compensation and where will this land go to. I would say what we suggest should be done is do proceed with the bill. because what we have is unconscionable and it's not in line with the duty in Krotbaum's, Scribante, and all of the constitutional court cases. It will also help us to clarify the constitutionality of expropriation, but it needs to be accompanied by a holistic policy framework on how the land will be distributed. Elsewhere, we also mentioned this bill will not unlock problems of looting of the money that has been used for land rights. For example, what happened in Malelane can still happen with this bill, because the land that is being targeted for expropriation without compensation is not land such as Malelane, where we ended up paying more than double the price and therefore undermining our ability to fund redistribution and restitution of land. So what do we suggest? Subject this bill to CS, which is a policy requirement, which is social impact assessment systems, to assess its proficiency and proportionality. In other words, does it solve the problem it claims to be solving? Are the choices it's making proportionate to the problem? But we also suggest, in addition to that, consider subjecting it to a social justice impact assessment matrix to ensure that there is greater fidelity to the Constitution and social justice commitment as envisaged in Section 9 of the Constitution, Section 7, Section 195, and Section 237. Chapter 4 and 5 should undergo a thorough review with a focus on ensuring a much more affordable and less complex system. And for the sake of social justice, you may also consider other approaches. We specifically suggest that in addition to this, we should explore a social compact process that will be complementary. And that social justice complex should be about teaching South Africans, as Justice Cameron says in Daniels versus Scribante, about what happened in the past and how does that past continue to define us, and encourage more South Africans who are hoarding land to redistribute that land on their own. So thank you for this privilege, and we hope that this process will conclude again before the next election. Thank you.
Thank you, Advocate Madonsela, for taking us through a very elaborative presentation. What are the opportunities in the bill? Where are the areas of improvement? Concrete recommendations. We appreciate that indeed. We will then open the floor just to get clarity questions from honorable members. Can you guide us, Committee Secretary? Anyone on the floor? There's no one. Can you take the presentation down? Team. Honorable Brataseth, let's start with you.
Chairperson, it's not often that we have a professor of constitutional law addressing us, so I must take the opportunity. Professor Madonsela, I wonder if you can just assist the committee with one or two issues. The first one is that the expropriation bill refers to the definition of property in the constitutional sense. In other words, all property. Most of your presentation dealt with land reform, but what is your comment, number one, on the fact that this bill in its current form allows for expropriation by the state of any property? In other words, immaterial goods property, business rights, a lot of property over and above land, which seems to be the major focus of the presentation so far. Secondly, what is your comment that this is not a land reform bill, but actually an expropriation bill, And expropriation bills, expropriation legislation around the world refer to the public good. My apologies. The building of a school, a road, an airport. But for the first time, public interest is now being included. And would you not agree that public interest can be whatever the governing party at the time determines it is? And that puts us in a very, very difficult situation. And then my final question to you, Professor, is Section 12 of the bill provides for null compensation in certain circumstances, and specifically on land that is vacant and not used. Now, how will this impact on areas such as the Ingonyama Trust from the province that I represent in the council, where tracts of land are unused, and this is not only unique to KZN, my apologies, Professor, but also to many other tribal areas around the country, where land is owned and controlled by the tribal authority, but not necessarily being used in any commercial sense. This bill, as it currently stands, would enable the state to go into Ingonyama trust lands, go into trust lands around the country, and take them because they're not being used for the public interest. And they would not have to exhibit any particular proof of public good that is required. So these are the constitutional challenges that I have. And my concern is the bill as it currently stands conflicts with Section 25 of the Constitution. And actually, the current wording makes the bill unconstitutional. And I'm very sure that the bill will be subject to constitutional court challenge. So if you could just respond to me on those particular issues, that would be greatly appreciated, Professor. Thank you very much.
Thank you, Honorable Professor. Honorable Khail.
Thank you very much, again, Honorable Chairperson, and greetings to Professor Makdumsel, and welcome the presentation. My question, I think, is related to the previous presentation before this one, whether the expropriation goes far enough to address whether the Expropriation Act, if this bill is passed, can it address, can it expropriate property that was dispossessed before the 19th of June 1913? Secondly, whether we could pass a legislation, and if that aspect is not yet addressed in terms of the amendment of the Constitution. The third point is that already there is a socio-economic impact assessment that we receive from the DPME through Department of Public Works and Infrastructure. We already have that as a requirement. I understand that Professor is suggesting another process, which I don't think necessarily it is a requirement, a legal requirement, but I think it's a suggestion on her part. Thank you so much for now, Honorable Chairperson.
Thank you, Honorable Khail. From my side, Prof, in the current version of the bill, after receiving the notice of intention to expropriate, the recipient must decide whether he or she accepts or disputes. If the amount of compensation is disputed, the person cannot make a counter offer, and instead the disputed resolution provision must be applied. And the parties must either mediate or go to court. I'm interested to get a sense, to get the view of Advocate Madonsela on the insertion of a provision that allows agreement to be reached between the parties based on a counter offer in response to a notice of intention to expropriate. What is your view in relation to that, Advocate? Over to you.
Thank you, sir. Oh, Thank you, honorable members. Again, the questions are quite instructive. Let me start with the question from Honorable Breton Sir on the possibility that the bill will allow the expropriation of property beyond land. It is so, and it certainly makes sense, because when land has to be reassigned, often what is on it and is movable also needs to be expropriated. This could be buildings on the land, or it could be permanent fixtures on the land if it's a farm. So it makes sense that the expropriation would go beyond land. But you're raising a question about the possibility then of just expropriating property unlinked to land, which could be used because we make laws for good executives and administrators, but in reality, the same laws could fall in the hands of evil men and women. And we've seen that in the last 30 years, that some of the laws have been perverted by those who had the power to implement them. So maybe the committee could rethink. Maybe the committee could rethink the separation of property that is not attached to land from property that is attached to land. So I do agree to that. So, regarding your second question about in other countries, expropriation is only limited to public good. My response to that is that South Africa is an outlier. Former Chief Justice Chasterson once gave a talk on transforming constitutionalism and referred to the pre-constitution South Africa as South Africa through a wicked state and wicked laws. So there are very few countries where the state instrumentalized the law to prevent a section of the community from owning land, brutally remove whole sections of community from land to make way for a smaller section, and in the process created the disparity. I'm not quite sure what's going on. If people could mute their, I'm just asking if honorable members could please mute their.
From the chamber,
Yes.
Professor, from the chamber.
Okay. So I was saying South Africa is an outlier in terms of what happened in the past and how that continues to define the present, as indicated by Ms. Senege and Minister of Finance Assistant Theodore, Justice Tex in PE Municipality, and Justice Cameron in Daniel Justice. So those are the consequences of our evil past. And one of the reasons we have had regressive laws in our land reform system has been that we've tended to get advice from others and copied and pasted from them. That's why we're in a worse situation regarding equitable land redistribution or equitable land distribution when we were, when so quietly lamented the impact of the 1914 Land Act, which had only given Africans about 8.5%. It was corrected around 1936 to bring that distribution to about 30%.
Sorry, Professor. Can you just hold on so that we can conduct the chair in the chamber, because we're now missing out on your response because of this feedback from the chamber.
Thank you. Thank you,
Yeah,
sir.
thank you so much. Honorable Chairperson. Honorable Chair. I'll call the committee secretary, Professor McDonald, and find out, because we are unable to hear you now because of the challenge.
Thank you, sir. It seems to have gone. May I proceed, sir?
I think so, yes, it's gone now, yes.
Thank
I
you,
wonder if they are able to hear us from the chamber.
Okay, just maybe just to summarize that, I was saying, unfortunately, we have to differ from other countries, and that's what the Constitutional Court has said in Batista, Daniels versus Cribante, and many of the other cases, because we are an outlier in terms of the evils that happened in our country and the consequences of those evils. But we are warned in Makwanyane that in correcting the consequences of the evils of the past, we should do so from the basis of Ubuntu. In other words, we need not create new injustices. Whatever is done has to be in line with the Constitution and has to be proportional. And therefore, in this particular case, the guardrails are found in Section 25 itself, and further guardrails are found in Section 36. Regarding Section 12, talking about nil compensation on unused land, that was one of the areas of concern for us, about merely just presuming that if land is not used, then it must be ready for nil compensation. There are other tools available for government to prevent what is called speculation. And unused land has tools to deal with it. And you speak about what are the implications of this for rural areas. The Dlamini case that I spoke about is exactly one such rural case, where a family had used this land, and when the father of that family passed on, and the family was still trying to figure out how to proceed with farming, the local traditional leader decided to repossess that land. It's a distortion of customary law. It's a distortion of customary law as giving leasing rights, and Bugaitobi covers that very eloquently in the Ngwenyama Trust Act. But we wouldn't want this act to reinforce those perverse practices that have primarily affected women, although they've affected families, all families in rural areas. And therefore, consideration should be given. In fact, we ask a question in our presentation: will expropriation without compensation necessarily unlock the kinds of intractable cases we've heard? Let's take Malelane. Malelane, where we ended up paying more than double the price. Those are the cases that have stolen the resources for land reform. Expropriation without compensation is not necessarily going to unlock those cases, especially if it's targeting the kind of land that it is talking about or property that it's talking about. But we're not against expropriation without compensation, because expropriation does happen. It has always happened, and this bill is just aligning it with the Constitution. And there are various reasons why expropriation should take place. But you are warning us that a good law in evil hands can be used in perverse ways that do not advance social justice, but perpetuate injustice. Again, something could be done to review the bill. I'm going to talk to the land section at Stellenbosch University, Prof. Pinar and Prof. Zaza, to find out what can we suggest for refinement purposes. And then Honorable Khayi, does expropriation address what happened before 1913? This bill, as Honorable Brettenser and others have said, is not a land reform bill. It's an expropriation bill. We do have a restitution bill, which is a separate bill, and this is not that bill. And I think that's one of the challenges with our land reform, a challenge that has been noted by Prof. Rugeje, Prof. Hall, Ruth Hall, and many others, that we should consider an omnibus statute that deals with all of the issues around land. And in so doing, we might even separate land from other forms of property, so that when we're trying to regulate land, we don't end up inserting provisions that will be used for unintended consequences on other forms of property. Honorable Khayi, you're correct in saying the bill has been subjected to a CS impact assessment, but we noted that the impact assessment does not really deal with the issues of policy proficiency and proportionality. CS is what we refer to as a RIAT, Regulatory Impact Assessment Tool. And properly used, it can deal with all unintended consequences, and it can ensure that a policy being adopted to solve the problem optimally solves that problem, whilst minimizing negative unintended consequences. But if it's done the way it's done, with just ticking here and then, without using data to predict and bend the future, then you get laws that have been subjected to CS, but they've really not been subjected to a proper regulatory impact assessment. What we are proposing in addition to CS is what we call a social justice impact assessment matrix. It has 9 questions that squarely talk to constitutionality, talk to in what way is the bill aligned to constitutional objectives, or is congruent to constitutional. Who is the target beneficiary? Who is the target regulated community? Will they all equitably be affected by the bill? Our assessment at this stage is that the poor will continue to pay more, as they have done primarily since 1999, when there was a policy change to try and beef up the middle class, but also to move away from fostering ownership to giving people opportunities to lease, and people being given 30-year leases, which obviously places them in an inequitable position in comparison to those who benefited under colonial and apartheid rules. So CS and CM used together would ensure that we predict the future. We place this bill in some kind of simulated environment to look at how will it impact on different groups in society, which didn't happen when policy changes happened from 1999. The impact of those policy changes between 1999 and 2023 has been to exacerbate inequality with regard to land rights. And this was not the intention of policymakers. This was the inability to test congruence between the policy choices and constitutional imperatives, and use disaggregated data to predict how different groups will be impacted by any planned law, policy, or program. But more importantly, to understand that the Constitutional Court has said every law must not only not discriminate directly or indirectly against any group in society, but every law we pass, says Moseneke in Van Heerden, must move the needle forward in terms of achieving equality. And that's the same thing that is being said in Grootboom, Scribante, PE Municipality, Zondi, Mwelase, and many other land cases that the Constitutional Court has dealt with. Lastly, on just the scheme that is set up in Section 12 and around compensation and around, firstly, when there's a conflict, then government determining compensation, determining pricing, which must then be confirmed by a court. But firstly, by starting with mediation, we like that idea. We do think, though, that there has to be a distinction between a certain level of estates where the cost of litigation should be borne by the state and estates that are higher than a certain amount. Because social justice is not about treating everyone the same. It's about treating everyone fairly by being equitable in our treatment. Again, thank you, MPs. Thank you, honorable members, for this process. And we do hope that this time around, when this bill goes to the president, it will be signed. We take a dim view of the fact that laws are passed by parliament and not implemented. And then later, they come back to be changed without ever having been tested. And we think that should stop. If anybody is unhappy with the bill, they should engage in this democratic process in parliament. If that process fails, they should then take the matter to court. But the stopping of laws from implementation at the level of the executive is why South Africa remains unequal today, in addition to other mistakes we've made, including corruption. Thank you.
Chairperson, you are muted.
Chairperson, we've not been able to hear you, sir. You are muted.
This is a daily occurrence.
Can the technical team help me?
We can hear you now, sir.
Can hear you now, Chair, but please ask the... Please, Chair.
Thank you, Prof.
Chairperson?
This opportunity. Honorable
Chairperson?
Is there a follow-up?
Please ask the committee secretary to have his phone so that we can contact him when we can't hear you.
Thank you, Honorable Khai. He has indeed captured that. We will impress upon him.
Chairperson, before you summarize, I just wanted to ask a question. I got bumped off the platform here. Whether
Unfortunately, Mr. Mai, you had an opportunity. You were the first one to present. We are done with your part. So now it's other presenters. So after presenters, it's only members that are engaging on 30-seeking questions. Unfortunately, the rule doesn't make provision for that. I will ask you to interact with the committee secretary as you have been doing. Can we then take this opportunity just to take a 10 minutes break? Thank you, honorable members. 10 minutes break.
Yes.
consistently that Mr. Mzwanele Manyi is raising his hand. Let me just inform Mr. Manyi that in terms of the rules of the House, he's a member of the National Assembly, not a member of the National Council of Province. And that upon the reflection and the National Council of Province passing this bill, and there are changes made, those changes will be referred to the National Assembly. And as a member of the National Assembly in that house, you will have an opportunity to participate. The rules of the National Council of Province House does not make provision for him to participate because he's not a member of the committee, he's not a member of the House. I just needed to clarify that point, that his continued raising hand, it needed that clarity to be given. I see Honorable Tim Brataseth, you have your hand up.
Chairperson, yes, I think I just wanted to help you with a bit of housekeeping as well, Chairperson. Chairperson, I'm also aware of the chat function on this meeting, and I think the chat function is a good function and should never be excluded. But Chairperson, this has always been a cordial committee where we engage each other robustly but respectfully as well. And I've just noticed that in the chat section on this meeting, there are certain comments that have been directed towards presenters that are less than complimentary. And I feel that we should just observe the decorum of the House and ask members that persons attending that are not members of the committee to perhaps refrain from insulting presenters in the chat group. I don't think that's the kind of record we would like to show as a committee to the people of South Africa. Thank you very much.
You are correct. You have correctly captured. The position, Honorable Brataseth. Let's just remind guests that that is not allowed because only members of the select committee can engage, and in their engagement, they are governed by the rules of the House, which calls to how we conduct ourselves as members, the decorum. The charts are part and parcel. So if you do that, you are not protected by the privilege that members has, and you might open yourself up for action because only members of the House have that protection of privilege. So any insult on the chat room, you are making yourself liable to be sued. So I just needed to remind the guests that are part of this public hearing to refrain from doing that. Without any waste of time, can I then invite Mr. Thapelo Motshweni to take the floor? Over to you.
Thank you, Chair. Good afternoon, members of the committee in the House and on the platform. Good afternoon to everyone. I'm Thapelo Motshweni from the Office of the Valuer General. Chair, I'm joined by Ntate Tsenolo Masoleng, who is the Senior Manager at our PMO, and Me Tiny Dlamini, who is a professional valuer. She's a Senior Manager responsible for property valuations. Chair, ours is quite a narrow one. It's not a very lengthy submission that we have made. We're zooming into valuations, the determination of values. As you would know, Chair, the values that get determined by valuers form a major part of the compensation that gets paid in matters of expropriation. So that's what we're going to be dealing with. Mr. Masoleng will take us through, and myself and Mayor Dlamini will assist with questions as well. Thanks, Chair.
Thank you, Chair, and good afternoon to the committee members. Chairperson, I will dive straight to our presentation and deal with the OVG's overview. Chair, in our overview, we're just highlighting critical or important or historical events that led to the formation of the OVG and what OVG is about. In this slide, we state that the OVG is a state entity which reports to the Minister of Agriculture, Land Reform and Rural Development. And the OVG is established through Property Valuations Act number 17 of 2014, which we call the PVA. The mandate of the OVG is to support the program of land reform through provision of independent and credible property valuation services and to conduct valuation for all government departments. Although the OVG works closely in cooperation with the other institutions in the rural development and land reform portfolio, it continues to do so with a significant degree of autonomy that will add further credibility to the land reform processes for the benefit of all the stakeholders. Chair, looking at the genesis of the OVG that is embedded within the Green Paper of land on land reform, the problem statement in the Green Paper on land reform states that South Africa lacks a nationwide, comprehensive, reliable, and collated hub of property values. And there is also absence of legislative framework to determine when market value is one of the variables in determining values as opposed to being the only criterion that is utilized to determine the values. And also it questioned some of the probity of valuations that were conducted, particularly for land reform at that particular point in time, and also raised questions of conflict of interest and malpractice in the valuations that were conducted at the time, improper or hurried valuations in order to meet deadlines or compliance planning, and a historical or mechanical approach to valuation. So the OVG was meant to come and address those challenges that were raised in the Green Paper. Let's look at the mandate. Why is the OVG there? The mandate says in the Property Valuations Act number 17 of 2014 that whenever a property has been identified, for purposes of land reform, that property must be valued by the Office of the Valuer General for purposes of determining the value of the property, having regard to the prescribed criteria, procedures, and guidelines. And then we've got section 12.1b, which talks to whenever a property has been identified for acquisition or disposal by a department for any reason other than that mentioned in paragraph A, which is land reform, the market value of such property may, at the request of a department, be determined by the Office of the Valuer General. Chair, I've just briefly highlighted what section 12.1a and section 12.1b says in the previous slide in as far as the founding mandate of the OVG. This slide tries to amplify what is in the previous slide. If you look at the section 12.1a block, you will see there that it's predominantly a land reform type program where we are sitting with the Commission on Restitution of Land Rights and the Department of Rural Development meaning that key stakeholders there are land tenure reform and strategic land acquisition, which are branches of the department. What do they do? They acquire land for restitution for land claimants, pay compensation for land claims where land is not restorable, acquire land for redistribution purposes, acquire land for farm laborers and dwellers, and claims and addresses claims for restitution purposes and tenure security. If you look at Section 12.1b, Chair, Section 12.1b, we've done work for Department of Water and Sanitation and Department of Forestry and Fisheries. And the purpose for those valuations is primarily to facilitate the process of land acquisition and land disposal. So, Chair, if you look at the purposes of expropriation, both on Section 12.1a and Section 12.1b, you will see that the valuations that the OVG conducts covers both public interest and public purposes transactions. Now, Chair, in our overview as also, we need to highlight the importance of alignment to the prescription that we've got, or the prescribed factors that are mentioned in Section 25(3) of the South African Constitution. As OVG, whenever we conduct valuations, we look into these factors, and where there is sufficient information to determine the property value based on all the factors, we do that. So the factors that are stated in Section 25(3) of the Constitution is the historical value pertaining to acquisition benefits on the property. Not sure what happened. The market value of the property, current use value of the property, the purpose of acquisition, and direct state investment. So that's just amplify the alignment between the Property Valuations Act and Section 25(3) of the Constitution. Chair, looking at the overview, we do valuations across the country, although our office is located in Pretoria, but we do valuations across the country. So, Chair, coming to the amendments that are proposed by the OVG for the purposes of the bill, I just request a second. I've got some pop-ups that are in my screen that are limiting my view in terms of what I'm presenting. I just want to sort that out. Okay, all the proposed amendments falls under the following areas of the expropriation bill. We're focusing on Chapter 3 of the bill, which deals with investigation and valuation of property. And there is a section that the OVG proposed that it should be added into Chapter 3. We'll explain, we will deal with the details in the subsequent slides. On the proposed amendments, I think what we are mainly saying that the expropriating authority, as specified in the bill, should collaborate with an organ of state that specializes in valuation for land reform or expropriation. Although the proposed amendment does not explicitly prescribe the nature and form of collaboration, it is suggested that the collaboration should be founded upon the following principles: define key areas of collaboration regarding property valuations for expropriation purposes, defined governance processes, roles and responsibilities, services offered, defined technology and infrastructure requirement, funding, defined technology and infrastructure, and defined platforms of engagements. The above should be part of a signed agreement between the expropriating authority and the relevant state organ. The Under the proposed amendments, we proposing that the expropriating authority to collaborate with the organ of state that specializes in valuation, reform, or expropriation, firstly, to determine the criteria for the determination of value. Such criteria will assist with the following: defined requirements and qualifications for conducting such valuation, defined rules for valuers who are responsible for such valuations, compliance to the Property Valuers Professions Act. The second one, Chair, the expropriating authority to collaborate with an organ of state that specializes in valuation for land reform or expropriation to determine procedures and guidelines, including methods of valuation for the valuation of properties, the manner in which evaluation must be performed, and any other relevant factors. Such procedures and guidelines will assist with ensuring alignment to the relevant legislation and standards that governs real estate and property management activities, which include but not limited to the following: the Constitution of the Republic of South Africa, the Municipal Rates, Property Rates Act, Municipal Finance Management Act, Public Finance Management Act, International Valuations Standards. The third proposal, that collaboration should assist in the development and implementation of a system that will monitor compliance with the criteria and procedures. This will be a monitoring component of the partnership or of the collaboration, where there is a review of compliance with the standards that have been defined. So that process will assist with providing oversight, quality assurance, and review processes for the technical elements of valuation, monitoring the ongoing integrity of valuation services provided by the valuers who are conducting such valuations, management, maintenance, and coordination of the valuations data, supporting downstream processes with the necessary insight regarding property values, impacts on budgets, expenditure, etc. Chair, on this slide, we're dealing with the issue of the reporting when it comes to such valuations. What should the reporting be like? What should inform the template? How do we standardize? How do we make sure that all information that pertains to valuation of that particular property is well documented in a standard format? And that will assist in ensuring consistency in terms of conducting valuations and the documentation of critical valuations data, generating a seamless repository of valuations data, standard and accessible valuations data for reference and analytics purposes, ability to provide expert advice, including valuations, expert witness capabilities in a court of law with ease. Chair, in conclusion, in summary, the proposed amendment suggests that the expropriating entity should establish the specialized partnership that will assist with the following: defining standards and processes for conducting valuations for expropriation for both public purpose and public interest, providing an oversight role on how the agreed standards and processes are applied by valuers who are implementing those standards, play a role in developing insight on properties that are valued for expropriation purposes, play a broader advisory role on matters relating to valuations for expropriation for both public interest and public purpose. Chair, we thank you.
Thank you for the brief presentation, clearly articulating the area of interest, concrete three proposals in relation to processes, in relation to land reform. I will take the opportunity to invite members to engage at the level of clarity questions. I have noted Honorable Bratiseth, the floor is yours.
Thank you, Chairperson, and thank you to the Valuer General for their presentation. Very briefly, Chair, my question to the Valuer General is, I note from the presentation that their ambit is primarily dealing with state land. So in other words, their work, their office with state organs, and how they determine compensation. Would the Valuer General be prepared to offer comment on what happens when the state is dealing with private concerns and private property? Thank you, Chairperson.
Thank you, Tim, for that question. Just in terms of from myself, a bit around the constitutional property, which might include rights to minerals, limited rights, claims for justified enrichment, intellectual property, and what can be expropriated. My understanding is that what can be expropriated is constitutional property for expropriation, not restricted to land. Yeah, I think that is the sense that one gets. But of course, I think the angle is also amplified by our understanding in terms of what departments mainly in the bill are identified as authority for expropriation. So now the question is, if the proposal is that the amendment be made to be exact in terms of the structure that must be instituted, that must be included, must be the Office for the Evaluation General. Is it not sufficient just to say an office related to the relevant evaluation, not necessarily evaluation for land reform? Because as you have correctly pointed out, you report to the Ministry of Rural Development. They are mainly centered around instances where a property has been identified for land reform. Then you must evaluate. Is it correct to have a restricted version, or have a wider association or a body that will include valuation in general? The second one, the three proposals that we are making, can they be covered by, let's say, the regulations? Do we have to be more pronounced in the bill? And then just the last one, the assumptions that we are from the executive, because they report to the ministry. Usually we expect when the bill comes to us, the executive should have had an opportunity to interact, so that when it comes to us, at least those that are part of the executive have had an opportunity to comment, or probably maybe in your interaction, because definitely you are a very critical stakeholder in terms of land reform. No interaction between the Department of Public Works and the Department of Agriculture and Rural Development. Over to you.
Thanks, Chair. I think let me start with your questions. Yes, so we are part of the executive. In terms of the PVA, we do operate autonomously from the department. There is a large degree of cooperation, but that level of autonomy is maintained, particularly to ensure that the citizens see an even-handed manner in which their matters are being handled. Not only do they see it that way, but it is actually so. We do have the blessing of our minister to make the proposals that we are making. So we touched base with her before we could come here. About covering with regulations, it's an option, Chair. It remains an option because regulations will pretty much serve a good purpose, which would be, well, this would be a good purpose. It obviously stronger when it's in the legislation, as it is more superior legislation. The law, the act, would be superior to a regulation. So our suggestion is actually that it goes into the act. As far as a wider definition is concerned, when a valuer, a property valuer, faces an assignment that includes specialist requirements, like specialist skills, they are allowed to bring those skills on board. For an example, there's artwork that they are valuing as part of the property that is being valued. They may bring on board an art specialist valuer who can do that type of work. And that will go across the many skill sets that we have, the many specialized areas that we have. We actually make provision for it in our technical manuals, I think in the regulations as well, that where they require specialist support, they bring it on board. But the good thing about tying it to the SAC PVP in our case, which is, by the way, the South African Council for the Property Valuers Profession, for our case, when we were starting out, the good thing was that you benefit from the ethics that are demanded by virtue of professional registration, managing consequences, levels of competence and so on. So you piggyback on a system that is already functional. So that's why we were able to, or we insisted on linking it to the South African Council for the Property Valuers Profession Act itself. I hear what the chairperson is suggesting about a broad definition that talks about a valuations outfit in a specified field. And I guess that's why we also came up with a broad proposal on not a specific entity per se. We just said an entity that deals with land reform, such as the OVG. But I hear that what the chair is proposing is that even beyond the valuation of land, the valuation of other property, and I think it would be a good addition, because then expropriating authorities would be expected to demonstrate an application of mind as to how they have gotten to the point where they have determined a certain number as the value of that particular property. The first member of parliament, the surname is difficult. I'll just refer to him as the first one who spoke. About state organs, yes, we exist to support state organs, 12.1a and 12.1b. But we do so even when they are interacting with private citizens. So for an example, an expropriation of, or rather, let's just say a restitution matter between a private citizen and the Commission on the Restitution of Land Rights is a matter that we will deal with. In fact, close to 100% of our matters are between the state entities and private members of the public, be it land claimants or landowners, whether it's for restitution or the redistribution program. So I think I've covered all of them. I don't know if my colleagues would like to add. No. Yeah, we think we've covered all of them. Thank you, Chair.
Thank you, Mr. Mtsweni, and your team. It looks like members were more clarified in terms of your presentation. They are happy. And then allow me to take this opportunity to indeed express a word of gratitude to the appearance of the Office of the Governor General led by yourself and your team before us. It has added another element of value in terms of the work that you do, and therefore you are free to remain with us until we finish. At the same time, we are mindful of the fact that you might be having other pressing issues, but indeed, our gratitude on behalf of the Select Committee. Thank you. Thank you, honorable members. We will now move to Mr. Ernest van Sey. Afrifora.
Good afternoon, Chair. I'm present.
Oh, great, brilliant.
Right.
The floor is yours, Mr. van Sey.
Thank you very much. Good afternoon.
From Afrifora.
That is correct.
Thank you.
Good afternoon. I am Ernst van Zyl, and I'm here as a representative of the civil rights organization AfriForum and our over 313,000 members. The expropriation bill should not pass because it will cause economic devastation, contribute towards a food security crisis, and enable human rights violations. Furthermore, various sections of the bill are unconstitutional and can and will be challenged in the courts, very likely successfully. If this bill were to become law, it will deprive citizens of their constitutional right to private property, and the destruction of the right to private property through this bill will have a very negative effect on foreign and domestic investment, as well as job creation. This bill's purpose cannot be construed as to right the wrongs of the past. It only enables further wrongs to be committed in the present. And you cannot fill an old pothole by digging a new one. Detailed surveys and even the government's own reports and statistics repeatedly point to the same politically inconvenient truths, some of which I will share with you and put on the record here today. Number one, politically inconvenient truth number one. The vast majority of people in South Africa regard the need for land reform as a very low priority. According to extensive polling, the number of South Africans who believe that more land reform will improve their lives currently stands at a mere 1%. The main three problems identified by these polls were employment, education, and crime. This comes as no surprise to anyone who is not increasingly disconnected and detached from the man on the street and the problems that he faces. Politically inconvenient truth fact number two. The so-called hunger for land that we often hear about in political rhetoric is largely a myth, particularly with regard to rural or agricultural land, and I'll explain why. South Africa is urbanizing at a rapid rate, not ruralizing. About 80% of all land claims were lodged in urban areas. It is also a well-documented fact that more than 90% of land claimants over the years declared that they would prefer money as compensation rather than the land to be restored to their ownership. This is according to the government's own admissions. The hunger the hunger that we see out there is not a hunger for land, but a hunger for jobs, a hunger for the end to corruption, a hunger for quality education, and a hunger for safe streets. That is the reality on the ground if you speak to normal South Africans that you encounter every day. Politically inconvenient fact number 3. Over 66% or 2/3 of the country gets rainfall levels that are globally classified as semi or true desert. True desert areas such as the Karoo and Kalahari cover 55% of the land in South Africa, or approximately 66 million hectares. A province like the Northern Cape has almost no arable land relatively to the other provinces, but it is by far the largest province by total area, more specifically around 30% of SA's land area. Go look at the Northern Cape province, the largest province by far, on, for example, Google Earth. That would be my challenge to you afterwards. You will think that you're looking at the surface of Mars if you were to do so. Even better, go drive through that province. It will be, go drive through that province. I know it personally very well. I come from a long line of tough desert Afrikaners that have been farming in that province for many generations. Nobody except the most hardened farmers whose family have been living and farming in these harsh conditions for generations have any hunger to live there, let alone farm there. A significant amount of white-owned farmland is located in arid desert or semi-desert areas in the western part of the country, where the carrying capacity for livestock from natural grazing is significantly lower than in the eastern parts. These facts demonstrate how land statistics are more complex than just mere percentages. The government's land audits and politicians espousing land rhetoric do not take into account the agricultural potential of land, or I have not seen any proof of this. A province like the Northern Cape's massive land area and the nature of what it takes to successfully farm there strongly influences the national statistics regarding land ownership. Politically inconvenient fact number 4. Around 90% of land reform projects in South Africa have failed. And this is according to many authoritative sources. And commercial farms are converted into subsistence farms or squatter camps through this process. But why is that? Is the very, very important question. Because many of these projects these land reform projects were allocated to the politically connected who have no knowledge or experience of farming, or where they were allocated to people with knowledge or experience of farming, it was without any of the promised feed, seed, tractors, or other forms of support. These potential farmers were let down by empty government promises. They were doomed to fail from the start. They never stood a chance. And this trend continues to this day. Politically inconvenient fact number 5. All of the land that the government has acquired since the start of the land reform process, around only about 6% has been transferred to private ownership, according to the latest statistics. The state owns approximately 17 million hectares of land, and that is the surface area, for perspective, of the provinces of KwaZulu-Natal and Mpumalanga combined. Then you also need to take into account that another 8.36 million hectares is officially unaccounted for, although much of it is expected to be accounted for as government-owned land. That's another approximately Mpumalanga-sized chunk of land in the hands of the state. Can the government prove that it can redistribute some of the land that it has in its hands? The track record of the government gives us a resounding answer, and that answer is no. Redistributing land to ANC cadres or the politically connected does not count either. Politically inconvenient fact number 6. I've heard many politicians say that the land that will be prioritized for expropriation will be fallow land. Why is land often left unused or fallow by farmers? If you come from a farming community like I do, you know why. Because often land needs to be left to recover and regain its fertility instead of farming on it every year, Like I said, there's more than meets the eye to farming. It's complex business. If the government sees no problem with expropriating unused or fallow land, can the government also expropriate your savings, the money you're not currently using at the moment, or your clothes that you don't wear every week? Can that also be expropriated? According to this bill that says that any form of property can be expropriated, they might as well will be able to if it were to be passed into law. There is no evidence that this bill will empower the majority of South Africans or produce economic growth or jobs. The bill is the result of a set of ideologies that have been tested and failed horribly and repeatedly. History and our own Zimbabwean neighbors have shown us that tampering with private property rights, central planning, and excessive government control does not lead to economic growth nor to increased levels of equality. It always leads to the contrary. It always leads to economic decline, human rights violations, corruption, and greater inequality. Furthermore, expropriation without compensation violates international law. The European Court of Human Rights has held unequivocally that expropriation without market-related compensation will violate international human rights standards. A 2012 study of state practice by the UN Conference on Trade and Development stated that, and I quote, "Failure by a state to pay any compensation for a direct expropriation can be seen as rendering such expropriation unlawful," end quote. AfriForum demands that this bill not be passed and that the right to private property in this country be protected rather than destroyed. The existing land restitution process has been derailed by corruption, political greed, and mismanagement. Rather focus your time and energy on fixing that legitimate process of land restitution that is already in place. The problem is that the problem is not the willing buyer, willing seller model. The problem is that the ANC government has proven itself to be an unwilling distributor of the land that it has hoarded. Due to the failures of the ANC government and rampant corruption, South Africa is currently experiencing an electricity crisis, an unemployment crisis, a crime crisis, an education crisis, and an open borders crisis. The expropriation bill will only add fuel to that fire, and that is an absolute guarantee. When Zimbabwe implemented its policy of expropriation without compensation, it led to the world's worst case of hyperinflation in history and the total collapse of that country's economy and agricultural sector. The average Zimbabwean was left destitute after the economy was destroyed, with millions fleeing and continuing to flee to South Africa, even though they have the land back home. That should tell you everything. But AfriForum is not an organization which only opposes destructive policies. We also provide carefully considered, sustainable solutions to actually bring about good and prosperity. Number one, expropriation of property without compensation is certainly not the answer. You don't solve an illness by taking a poison. Solution number two, the restitution process that is in place. South Africa has a history of land dispossession. Therefore, restitution process has already been put in place, which AfriForum supports. However, this legitimate process of addressing the wrongs of the past has been derailed by corruption and mismanagement. Fix that existing sufficient process. Solution number three, support. Government spent over 1.4 billion rand on buying farms in the Eastern Cape to redistribute. It was reported that of the 265 farms that were purchased, only 26 remain viable today. In 90% of those cases of once thriving farms that produced food and employment, they all lie in ruin now. This fact has been acknowledged by the Department of Rural Development and Land Reform. Farming is not easy. It is a technical job that requires significant amounts of time, expertise, experience, and money, as well as substantial support and training if you have no background in farming. Providing someone with the land to farm is no guarantee that that farm will succeed. They need support, experience, and proper training. And in that regard, the government has unequivocally failed. Solution number four, honesty about the facts. That's why I listed all the politically inconvenient facts here today in regards to this debate. Politicians need to stop injecting misinformation, half-truths, and outright lies into the land debate for political gain. This does not facilitate solutions. It only misinforms people, fuels division and conflict, and muddies the waters. It's shameful and should not be tolerated at all. Solution number 5, protect the constitutional right to private property. Countless studies show that the protection and enforcement of private property is one of the key factors which facilitates economic growth, job creation, investment, both foreign and domestic, and political stability. Many case studies show that the destruction of private property rights has exactly the opposite effect on these metrics. Expropriation without compensation is state-sanctioned theft. It is legalized looting, deeply immoral, and a human rights violation.
Mr. Van Zyl,
Yes.
as you conclude.
Yes, this is in fact my conclusion. Thank you, Mr. Chairperson. It is an inhumane, ill-conceived policy motivated by a combination of corrupt greed, ideological possession, cynical electioneering, and a philosophy of revenge. The government is gearing up to violate the rights of millions of South Africans and cause an economic disaster, and therefore the resistance to this bill is so strong and growing. That is why this bill cannot pass. Baie dankie. Thank you very much. Kia leboga.
Thank you, Mr. Van Zyl, for making a presentation on behalf of the AfriForum. Just trying to check from the members. Are there any other participating question? We have Mr. Pratasa. Tim, the floor is yours.
Thank you, Chairperson. Chairperson, thank you to the presenter from AfriForum. The question I have for him is, what is his comment on the public interest section of the bill in relation to his presentation? Thank you very much.
Honorable Khai.
Thank you, Chairperson. In fact, that was just a political debate. It does not address the expropriation bill. Maybe he should be a member of parliament and also participate in the political debates that are taking place in parliament, because that speech was not assisting the committee to decide on the chapters that are on the bills and the sections and the clauses that are on the bill. It's just a political speech. So we invite him to contest the election in 2024 so that he can make regular speeches. So that's all I wanted to say. Thanks so much.
Thank you, Honorable Khai. Just one from myself, Mr. Van Zyl. The
Chair, I think you are on mute. We can't hear you. No, we see your lips moving, but we don't hear.
unmuted today. Thank you.
There you are.
Yeah, I have 2 questions that I want to pose to you. The first one relates to the transfer of property directly to a third party. The second one relates to the counter offer. There are 2 proposals that are made to be inserted in the bill. The first one is that the definition of expropriation in the bill does not contemplate the transfer of property directly to a third party. One of the recommendations from the department is that a provision be introduced at clause 2 of the bill to the effect that the third party transfers in the public interest are to be governed. What is your view in relation to that? The second one is that in its current form, the bill does not allow a person whose property is considered for possible expropriation to make a counter offer in respect of the remuneration offered by the expropriating authority unless a formal mediation process is initiated or a court is approached to make a determination in respect of the remuneration amount. So, what is your view in relation to inclusion of the counter offer? Over to you, Mr. Fansey.
Thank you, Mr. Chair. I'll start with the first question on public interest. Thank you very much. I think that's a critical question in regards to the public interest clause or the public interest qualifier. The whole idea of what would be in the public interest can be manipulated to mean anything any politician wants it to mean. I don't think there's ever been a political regime in the history of mankind that would not be able to justify its policies in its own twisted way it might be as in the public interest. I think that's not a good qualifier at all, seeing as every regime, both good and evil, every government in the world thinks that what it is doing is in the public interest. So I don't think that is a good qualifier at all. It can be twisted to mean anything. Then in regards, Mr. Chairperson, your questions, the transfer to a third party, I think, well, maybe the transfer to a third party part of the bill and then also the counter offer part of the bill, I can answer in the same way, and that is that the bill should not pass. It should not get to this point, whether that confiscated or stolen land, land that the government has expropriated, then transfers to another party. It should not get to that point, or rather also the whole thing about should the person whose land was expropriated be able or not able to put in a counter offer. That is, it shouldn't get to that point. Land should not be able to be expropriated without compensation in regards to how this bill is framing it, in the way that this bill is aiming, what this bill is aiming to enable. That's where it stops. The debate should not be about then what should be done with that expropriated land. Expropriating that land without compensation is wrong. That's AfriForum's stance. And then the last question that I want to answer is the question where, well, not a question, rather a statement that we from AfriForum did not address the bill, but rather just did a speech, and that we should go to Parliament. Well, firstly, we do address the bill and technically address the bill and many of its parts in detail in our written submission, but we're only given 15 minutes here to do a presentation. I don't think anyone wants me here reading our multiple page written submission for hours on end. You are welcome to go read that for our specifics in regards to this bill. So I'll use the 15 minutes allocated to us the best that I think it should be used. And in regards to the comments of we should rather go to Parliament with these types of speeches, if you are thinking that AfriForum thinks the best way to make a difference in this country is through Parliament and that we should become a political party, then you greatly underestimate our ambitions. Thank you very much.
Thank you, Mr. Francis. The last one. The bill is not introducing expropriation. There is a current act that was passed in 1975 that was used to expropriate. If you are listening to some of the presenters, the assertion is that the amendment is made to introduce procedures and systems to ensure that this old regime of expropriation is in line with the Constitution. What is your comment in relation to that?
Mr. Chairperson, my comment in relation to that is any expropriation enabled by this bill without compensation would be against the Constitution, Constitution Section 25. That's exactly why I made the point that if this bill were to pass, it will be challenged immediately in the Constitutional Court and very likely will be challenged successfully there. That's the central one of the central points of AfriForum's submission.
Thank you, Mr. Fansey. Tim, is there a Yes.
No,
Chair?
Chairperson, it's a follow-up, if I may, Chair.
Okay, the floor is yours.
Okay, Chair, just very briefly, Mr. Van Zyl, have you said that obviously you've engaged with farming communities, and you made numerous references to your own background and your family's background in farming. Have you had the opportunity to engage with tribal authorities that are obviously adjacent to or part of those farm areas, and how they feel about the possible loss of unused land as a result of the expropriation or the amendments to the expropriation bill? Thank you.
Thank you very much for the question. Yes, absolutely. I think if you go look at a lot of the amazing work that my colleague Barend Uys, the head of intercultural cooperation at AfriForum, is doing, that's exactly his entire portfolio is communication and liaison and meetings with traditional communities in South Africa, specifically surrounding the idea of land ownership and the future of land and the land debate. So I think seeing as I'm not the person that does that incredible work, if anyone has any further questions regarding that process, they are welcome to send Mr. Barend Uys email through AfriForum's website. He's doing amazing work. You can go check out on, I think, on YouTube as well. If you search AfriForum Joint Agricultural Project, you'll see a lot of the joint agricultural projects that deal specifically with land ownership and the future of agriculture and inter-community cooperation that AfriForum is doing through Mr. Uys's work. So absolutely, we have been doing a lot of conversation and discussions with traditional communities, specifically regarding land ownership and land from AfriForum's side. And those conversations have been very productive. And the sense that I've been getting, and also what I've heard from my colleague Barend, is that these traditional communities are also strongly opposed to, firstly, the state having the power to confiscate anyone's property at a whim, and then secondly, this whole idea of state owning all the land or having the power to expropriate without compensation any piece of land that it sees as in quote unquote the public interest, whatever the state means by public interest in that regard. So yes, thank you very much for that question, and I do encourage people to go look what AfriForum does in this regard in communicating with other communities in this country, rather than just believing what the misinformation that's out there. I mean, these types of stories unfortunately don't get covered in the media because it doesn't sell papers. Thank you very much.
Thank you, Mr. Van Zyl, from the AfriForum and your team. Allow me to take this opportunity to indeed express a word of appreciation for your honoring of the invite that the Select Committee made to the public. Your input will help us in terms of processing what is before us. And have a wonderful afternoon. Thank you.
Thank you very much, Mr. Chair.
Oh, thank you. I'm still trying to find my feet. I'm informed that the next presenter is Mr. Theo Dijachel from the South African Agri Initiative. You are welcome.
Chairperson?
Yes, Tim?
Chairperson, I'm sorry to interrupt, Chairperson. I just wanted to establish, it's now almost 1 o'clock. Has the committee meeting been extended for the day, or are we concluding after this presentation? I just wanted to know the way forward for the rest of the day. Thank you, Chairperson.
Yeah, we definitely have to have another day to finish our work. So definitely, it's going to be difficult for us to finalize all the presentations today. So we'll push up to 1 o'clock to 2 o'clock. That's what we said we must do, just to make sure that at least those that are in person that took the efforts to come to Parliament, we are then able to make sure that we accommodate them. I think that is the agreement that we have arrived at. Being mindful of the fact that there is an hour that we could not use and utilize appropriately at the beginning of the process. Thank you, Tim. Over to you, Theo.
Thank you. Thank you so much, Chair. I'm a fruit and timber farmer from Tsenin in Limpopo. I'm chairing our Family Farmers Network, SAI. Family farmer in South Africa, in our unique context, is not big or small. He's not rich or poor. He's not black or white. And he's not a newcomer or well established in the industry. It's a family that makes a living from a piece of land. I also carry the mandate, Chair, to do this presentation on behalf of the TLU SA, one of our networking partners, which is the oldest farmers organization in South Africa. They were established in 1897, and they gave birth to several of our SOEs in agriculture, of which the first one was the Land Bank in 1914. And together, we represent the largest body of farmers members in South Africa. Our main submission points stand on two legs. The one is legal, and the other one is in terms of investment in agriculture and the impact on that. As far as the legal part is concerned, we firmly believe that this bill is irrational as it fails to provide clear instances where expropriation with no compensation may be appropriate. And we feel that the semantics is very vague. What's the difference between no compensation and no compensation? It leaves the landowner in exactly the same position. We also feel that certain provisions of the bill are vague, and it may result in arbitrary deprivations of property. Now, it's important that we understand that the issue of expropriation without compensation is one of the core concerns of investors in agriculture. We have a difficult history over the last decade and a half where we saw investors shying away from bringing in the latest technologies, not only mechanical technologies or digital technologies, but also biological technologies, such as the latest varieties of fruits or genetics. And it's especially when you work with trees that there is a reluctance to invest. When you plant a tree, like on my farm, the trees which will be planted in this week, macadamia trees, will only be harvested in 2030. And the blue gum trees, which we have planted in February and March this year, will only be felled in 2041. Now, why would anyone plant a tree if you are not certain that you'll still be around to harvest from it, or that you will have the benefit of the harvest? You will never spend anything on a farm if you are uncertain that you will get paid for it when your property becomes the topic or the subject of a forced acquisition. Our public debate and policies and the legislation on this topic is really of concern of the majority of investors which we have engaged over the last few years. It's the first question that they ask. And we must have a law of general application on expropriation, like Professor Madonsela said. Of course, it must be updated to fit into our new constitution. But it must never give arbitrary powers to government officials. It must lure investors to our rural areas in South Africa it must not scare them away. Chair, in the debate today, for me as a farmer, it felt as if no one differentiated between land and farm. The farm is much more than a piece of land. It's a business. It must be profitable. It requires a lot of investment and a lot of management. Each one of us as farmers have a farm at risk under this law. Some of us might even have 2 or 3 farms. But the banks have all our farms at risk. All of us put our land as collateral with banks to get access to production financing. Very, very few farmers farm on a cash basis. And our land as collateral is really the cornerstone of agricultural financing. We have just more than 4,000 South African farmers today, farming in 44 countries elsewhere in Africa. But it is only here in South Africa and with our colleagues in Namibia and Botswana and Zambia where we have proper access to financing because we have integrity in title deeds. Once you erode that integrity, the production financing system goes through the floor. This is why the rest of Africa, we have not yet really unlocked the wealth from the soils. Farmers have been hampered by a lack of access to financing. It is also one of the main problems of our members who are beneficiaries of the redistribution program. They do not have title deeds. The title is still with government, so they cannot offer it as collateral to unlock financing. Being at the very center of the compensation debate in Zimbabwe, in SAI we have seen where the road of expropriation without compensation can lead to. We are today the biggest representative of Zimbabwean farmers who lost their farms in the fast-track land reform program. And we got to an agreement with the Zimbabwean government 3 years ago on compensation. It did not happen simply because the Zimbabwean government could not access financing to pay the farmers. Not even the Chinese government would extend a loan to them. There are at the moment 67 countries in the world who has embarked on land reform, 17 of them with the restitution program, of which we are one. And the issue of compensation is a heated topic in all of them. It is here in South Africa and in countries like Kenya, until about 20 years ago, of course in Zimbabwe and Venezuela, where the notion of nil compensation or no compensation gravitated to the center of the debate, shying away from market-driven land reform. I want to echo what AfriForum has said, that the problem with market-driven land reform has nothing to do with the willing seller principle. It is with a corrupt and an inept buyer. And we should just dust off the report, the high-level report of President Kgalema Motlanthe, which was tabled early in 2018, to see where things went wrong with land reform in South Africa. So, to summarize, we feel this bill is irrational in its current form, for as far as it does not differentiate between nil compensation and expropriation without compensation. They are vague and unfair provisions which may lead to arbitrary deprivations of property, contravening the Constitution and scaring away investors. The rule here is that capital is as shy as a kudu. When you scare it, it runs. Then we we feel we can learn more from the global experience on restitution programs. We want to emphasize the need for better implementation rather than resorting to expropriation without compensation. We want to stress the inevitability of compensation in such cases. You know, the story of expropriation without compensation always ends the same. At the end, governments compensate. This is the story globally. Even ZANU-PF got to a point where they said without compensating the farmers, they will never be allowed back into the mainstream of the global economy. And we want to reiterate the reservation of rights, including the possibility of future submissions. Let's go back to the National Development Plan. Let's go back to Chapter 6 of that plan, the partnership-driven model of land reform, where there is a proper balance between the interest of the state and the individual. Let's create a certain environment in which investors thrive. It's the only way we will retain our competitiveness on global markets and also our status as a food secure country.
Thank you, Mr. Jager. The Jager.
The Jager.
Okay, the Jager, yes. For the passionate way of presenting your case. Members, that's the presentation from Mr. De Jager, representing the TLU, South Africa. Any clarity-seeking questions from honorable members? Honorable Khai.
Thank you very much, Chairperson. I just want clarity on the presentation. Is Mr. Yassin say that in principle he doesn't have a problem with the expropriation? The challenge that he's having is around the nil compensation. Thank you, sir.
Thank you, Honorable Khai. Any further clarity-seeking question? Let me, while other members are still trying to find their feet, just again, the point that was raised earlier on around around the need to have an overarching a need to have a legislation that is in line with the constitution that talks to expropriation, because the one that we have now is not infused with the values of the constitution. In many cases, when there is an interaction with any act of the legislature or any act of the executive, the starting point is whether there is a rule of law infused in the decision, whether is the decision rational, whether is the decision transparent, whether the act that the executive took is it infused with accountability, and there are provisions in the Constitution, section 172, that makes provision for any act that is against that is deemed to be constitutional, that probably is found wanting when it comes to the Constitution, where the Concord has jurisdiction to set the matter aside. So now, the question that one want to pose is in line with the fact that the current act, the current Expropriation Act of 1975, grants the state the power to expropriate, but because it is not in line with the Constitution, hence the need to bring this, the current existing one, in line with the Constitution. What is your view in relation to that? Because there will be a number of acts, whether it is the Extension of Security Tenure Act, whether it is the Communal Rights Act, whether it is the Petroleum Pipelines Act, all these acts, to a certain extent, grants their respective departments to expropriate. But now this one is an overarching one that is in line with the Constitution. What is your comment in relation to that? The second one is the point that we raised earlier on around the need to have signage, because the current version of the bill, after receiving the notice of intention to expropriate, the recipient must decide whether he or she accepts. And if the amount of compensation is disputed, the person cannot make a counter offer. So the proposal is that there is a need to accommodate that, the counter offer, to amend the act to accommodate the counter offer. What is your view in relation to that? Because these are the concrete proposals that were made to us to say, do these amendments in line with the experience lift. Over to you, Mr. Diara.
Thank you, Chair. I really do not know of any country in the world that does not have an Expropriation Act. Every state needs an Expropriation Act. It is about how it is being done. That's what we are quarreling about. Now, unfortunately, Section 25(3) of the Constitution left us with a lot of vaguenesses. It has these discount clauses on which the state can decide not to pay market-related values, the history of the acquisition of the property, the state's investment historically on the property, the purpose of the expropriation. But the Constitution does not say to us whether the state can take a 5% discount or a 50% discount. This must be vested in a law of general application, which is the one we are discussing now. And it is here where, as farmers, we plead that the angle of the investor is also considered. There is no more important investor than the farmer himself. They say it takes about 3 generations for a farm to really be competitive. The first generation just suffers to pay the farm. It's a battle against the banks season by season. It is actually that second generation, the children, who has experience on this farm and to exalt, who becomes competitive. Very often it's the third generation that loses it again, because now cousins have got to farm together and they don't know where it came from. Or they can go big. We already have some 8th generation farmers, especially in the wine industry here in the Cape. Hence you will find brands of wine such as Four Cousins. The Retiefs, they've made it already since their ancestor was a gardener in Jan van Riebeek's gardens right next door here to Parliament. Now, for valuing it, I've listened carefully to the valuer general on where this institution fits in. You see, as we sit here today, agricultural debt is just more than 200 billion rand. This is what farmers owe banks. And the largest part of that is secured. Our farms are up as collateral with the banks, and if we don't pay them, they expropriate us in any way. So when you shake the trust in the integrity of title deeds, the banks make it more difficult for us to access financing. As it is, I really don't know how young people enter our profession. When young people come to us and say, I want to be a farmer, we don't know anymore where to send them to get a loan to buy a farm, let alone somebody who has got no track record of production to get production loans. And that's where you start your business. We have not only failed to get land reform right in South Africa, we have failed to create a class of profitable black farmers, because we have delivered them into a system where I do not know white farmers who will be able to make a success out of that system because of the uncertainty and title deeds and integrity in title deeds. The certainty that when I get expropriated, whatever I've put into this farm, I will get it again. That has been taken out. And it is much more than just the improvements on farms. It is also what the trees, the fields you have developed. Today, it costs much more than the farm itself. And Chair, even if we are expropriated at, say, 60%, 55% of the market value of farms, it will mean on average that the banks and the cooperative will get the money we owe them. But the farmer will walk out naked. There's no alternative for market-related compensation.
My gratitude on government's head committee on infrastructure for your response to our thank you, members. It looks like we just need to have Agri SA. Agri SA. The floor is yours. It will be most Army Barclays. Over to you. And our appreciation that you have been with us ever since this morning. You saw our teething problem. Thank you.
Thank you, Honourable
Over
Chair.
to you.
Thank you, Chair. And thank you to all the honourable members and of the Select Committee for this opportunity to present our oral submission to you today. We really do appreciate it, and that, together with all the administrative staff that make this possible. Thank you for that, Chair. Agri SA is a non-profit organisation that is committed to developing a stable, profitable and agricultural environment in South Africa. We are a federation of agricultural organisations consisting of 9 provincial and 26 commodity organisations, as well as 58 corporate organisations within the agricultural value chain. Through our affiliates, we represent a diverse grouping of individual farmers, emerging, smallholder, as well as commercial farmers. Regardless of their gender, colour or creed, Agri SA is committed to sustainable development in the agriculture sector in South Africa. Agri-SA has participated in the NEDLAC and parliamentary process from 2013 through to 2020, which resulted in the 2016 expropriation bill that was adopted by Parliament and forms the basis for the current bill. Agri-SA also participated in the constitutional review process on the possible amendments to Section 25. And our views expressed during that process are also relevant in the bill, insofar as it provides for expropriation without compensation. In a nutshell, Agri-SA is against expropriation without compensation, at nil compensation. Agri-SA recommends that the public participation process submitted by the local municipalities and provincial legislatures be scrutinized for compliance with regulations and guidelines in light of late notices in certain provinces, which could constitute a potential procedural irregularity. Technical issue, Chair, just trying to get the screen to go on. There we go. Okay, thank you. In general, I would like to address the committee on the general policy views of Agri-SA. We have submitted a very detailed report, Chair, regarding our views, the content, as well as issues regarding particular clauses. But I'm going to highlight today 10 major points that really form the heart of the Agri-SA argument. In general, Agri-SA does not support expropriation for nil compensation. The definition of expropriation as it stands is unacceptable. A landowner whose land is expropriated should always have recourse to the courts. Current landowners should receive prompt, adequate, and effective compensation, which will enable them to start anew elsewhere, and should not be worse off because of their expropriation. The full cost of expropriation should be borne by the fiscus. Individual landowners cannot be expected to foot the bill for land reform through reduced non-market related compensation. Payment of compensation should be immediate and in cash, and a transparent process must be followed in valuing land, where landowners should always have access to the valuation reports. Property rights lower transaction costs by providing an efficient resolution for conflicts over scarce resources. Production lending is what farmers access every day against the value of their assets to stay in production. The borrowing is done against the value of the land, fixed improvements, livestock, and machinery. The reason why production lending can take place is because the lending is done against the secure asset, vis-a-vis the market value of the land and fixed improvements. Without this form of security, a large percentage of commercial farmers would not be able to access production loans to buy inputs for the new season's crop, and would need to be planted against using either idle land and leading to the land lying idle or not being used productively. Expropriation should only be used as a measure of absolute last resort, and the purpose for expropriation should be clear. Procedures followed by the expropriation should be fair towards the landowner, and the principles of administrative justice should always apply. Under no circumstances should the compensation payment to a landowner depend on the state's ability to pay. The free market and the basic economic principles that drive developed and developing countries, from which it follows that transformation and land reform will not be possible if the liquidity in the food system changes. As stated earlier, Chair, we have submitted a detailed written report to the committee, and therein we make reference to certain terms and definitions that we have issue with. And we don't wish to go through those in detail today, and only wish to highlight the important factors. So we urge the committee to have a look at the detailed list, and I've provided the committee members with the documents of an actual table of each clause as it's addressed individually. So we have given that input. Thank you, Chair. So moving on to the main points that we do have issue with is the expropriation for nil compensation. It is the definition of expropriation that is a challenge. It is a humble submission that the current definition of expropriation limits the concept to instances where the state requires rights in property This definition excludes statutory limitations that undermine the economic utilization of property or dismantle its content from the concept of expropriation if the transfer of propriety rights to the expropriator is not included. In other words, the definition excludes constructive expropriation. The danger of such a narrow definition is that it may open the door for all kinds of government action that may severely limit property rights without compensation, or even the acquisition of property on behalf of third parties without compensation. The focus should be on the loss of the owner that the owner suffers and not on acquisition by the government. The state's authority to expropriate vests in Section 25 of the Constitution. The Constitution itself does not attempt to define or limit the concept of expropriation. The Constitutional Court itself has the ultimate authority to make a binding interpretation of any provision of the Constitution. Agri-SA proposes that the definition be deleted. This will allow the courts to deal with each case on its own merit. Alternatively, the definition must be wide enough to include all forms of expropriation recognized internationally. The exclusion of severe statutory limitations on the use of property from the concept of expropriation could have a negative impact on investor confidence and the growth in our economy. Moving on to I've now gone to the wrong slide, Section 12. In terms of Clause 12, the Constitution provides for courts to take all factors into consideration and arrive at no compensation. But it is the exception. By legislating for specific cases for nil compensation, expectations are created, and we've seen that today here, Mr. Chair, expectations are created for the taking of land at no value. Clause 12.3 states that any land expropriated in the public interest can potentially be targeted for nil compensation. The scope for expropriation at nil compensation is potentially too broad. The issue of compensation is of paramount importance to the members of Agri-SA. Whilst we acknowledge that no person should be allowed to unduly benefit from land reform and that deduction from market value may be fair in certain cases, we feel quite strongly that no individual landowner should be unduly penalized for something which is in the collective national interest. Agri-SA and its members harbor a legitimate concern that landowners may be undercompensated for their property. Agricultural landowners cannot be treated differently to other landholders, or for that matter, the holders of any other class of property. Agri-SA views land reform as a national priority, and as such should be funded with general taxpayer money. The agricultural sector cannot be expected to bear the cost of national priority. Landowners' land, whose land is earmarked for land reform purposes, must be placed in a position to continue to farm elsewhere. Compensation paid to holders of unregistered rights should be over and above any compensation paid to the landowner and not subtracted from the compensation due to the landowner. It is the administration of land reform and future expropriation processes that concern Agri-SA. This has been recognized in a number of studies and reports, including the high-level panel report. It is a humble request that the Select Committee refer to the detailed proposals regarding Clause 12 in our written submission. Moving on to the value of property and the impact of that and the Office of the Value General. A reduction in the recognition of property rights will endanger investment in the capital improvement of the land, both by primary as well as secondary agriculture. The financial sector will reassess its exposure to risk in this sector as this asset base is devalued and will diversify into other areas of the economy. Farmers would no longer have security to support loans, resulting in disinvestment in the sector. The economic reality of funding in agriculture is set out in Agri-SA's detailed written submission. We will now focus on the critical importance of property rights and capital in the agricultural sector in a brief summary. The basic principle is that the agricultural sector is funded against the collateral value of land, improvements, livestock, and the gross capital formation in agriculture. This is also contained, the value of this is contained and set out in our written submission. The GOPA Group study attached to our written submission found that a 5% decline in gross domestic capital formation will cause the real GDP growth rate to remain on a negative trajectory from the third quarter of 2021 onwards. And that's also visible from the graphs that are attached to the written submission. It is important to note that Land Bank's terms of borrowing include unencumbered property rights at market values. The international lenders they account to will call up this exposure where property rights are affected and the market values compromised. The 159.5 billion rand farming debt that currently exists from commercial banks and cooperatives will need to be serviced and represents a real contingent liability for the economy, where farmers will not be able to remain profitable. Where uncertainty of the asset class comes into play, that's land that cannot be expropriated with compensation, whether it is for public interest or where there are arbitrary principles such as land not being used and where the main purpose is to benefit from appreciation in market value, or land where compensation to be paid in terms of the Labour Tenants Act, the price of the asset class will fall due to market risk. Moving on to my final slide, and I promise I'll make this quick, just some important highlights. Firstly, property. The definition of property. Property is anything that can form part of a person's estate, including corporeal and incorporeal things, interests and rights. In principle, the protection of rights of an individual to a house, a farm, shares or intellectual property is well vested in international law practices. These rights also affect the holder of the right's ability to bond a specific right and the mortgage's holder's ability to securitize the right, be that through a security agreement, credit guarantee, express real security, or a usufruct. In modern economies, ownership of the said asset may be used to unlock financial value. We move on then to food security, Chair, where the food system comes under pressure from the declining market value. We find that there's a potential risk in food security for South Africa, Chair, and that this would lead to a tremendous and massive issue for South Africa as a whole. So the food security aspect linked to the property right is a real challenge. We'll find lack of investment in South Africa and the ability to unlock value from that land to farm in the future. And in reference to that, we have a look at what expropriation for nil compensation is done in Zimbabwe and Venezuela. And we can see directly in our report the impact of that. In Zimbabwe, we saw that the economy collapsed with the fast-track land reform program from 1991 to 1997. We've seen the effect on its economy, unfortunately. And the same occurred in Venezuela, where we saw the 2 years between 2017 and 2019, the country's GDP per capita halved at less than $2,600 per person. Hyperinflation exists there. In conclusion, Chair, what we're asking is, we understand there's a need for an expropriation act. That one exists, that the one before you is fairly good, but it is only really the question of nil compensation that we raise an issue with, and request that there are a number of other small aspects that we've highlighted in our main written submission. But the main question is, we would like the Select Committee to consider asking the President, he has the power to do this, Chair, to refer it to the Constitutional Court, yeah? To have it considered whether the clauses contained within the current bill meet constitutional muster. And if that's the case, then it can be assented to. Then we will avoid any further litigation going forward after the fact, once we've assented to that. So that's really the idea, is that we've noted there are some aspects that can be challenged, and we'd like to ask that if the opportunity arises, the President refer it to the Constitutional Court for confirmation prior to enactment. Thank you, Chair.
Thank you. Thank you. Ami Batley from AgriSA for passionate presentation. Thank you. Let me check the numbers.
Uncovered, Chair. Thank you.
Honorable Khan.
Yeah, yes, Chair. The presentation first started with the challenges around the definition of expropriation. and the focus was on nil compensation. Goes along, you find out generally the presentation is against expropriation as a principle, especially the last the examples about property rights, the food security, the examples of Zimbabwe, Venezuela, but especially the two property rights and the food security. I mean, if you read thoroughly on those, it's no longer now about the nil compensation. It's about the expropriation as a principle that agrees is against. Maybe they can clarify, Chef, with regard to that. But sometimes this issue of Zimbabwe, that is always a mention. It doesn't take into account the failure of Britain to stick to the Lancaster House agreement that was entered into by the political parties that were involved, including the British government. Sometimes we start it when the Zimbabwean government start to take the land without addressing the fact that what was a failure on the part of the British government to honor its commitments in the Lancaster House agreement. So I wanted to raise that aspect, because most of the time, those who are making example about Zimbabwe, they start from the issue of expropriation of land without compensation, without necessarily going back, giving it a historical context as to why the Zimbabwean government decided on what it decided with regard to the expropriation of land. Thank you so much, Chair.
Thank you, Chair. Just one from my side. The presentation by the department on the insertion of a provision that allows agreement to be reached between the parties based on a counter offer, because the current version of the bill is silent on that in terms of the counter offer. So are you comfortable with after receiving the notice of intention to expropriate, the recipient must decide whether he or she accepts or disputes? If the amount of compensation is disputed, the person cannot make a counter offer. So the department says, let's make provision for counter offer in the current one, because as it is of now, there's no provision for counter offer. What's your view in relation to that? You can start. I see Tim again has his hand up. Tim, I thought you said you were covered.
Chairperson, I was, but then a question popped into my mind. Thank you very much for your very kind indulgence, as always. Chairperson, I don't want to get involved in a debate with my good colleague, Honourable Khai, about Zimbabwe, because we're dealing with South Africa, not Zimbabwe. But the question I just wanted to ask is whether Agri-SA have contemplated the lopsided nature of these processes, in terms of, if the state decide to expropriate and they inform the property owner that they're going to expropriate, there's no cover or no provision for any legal representation on the side of the property owner, whether that property owner is a tribal authority or a farmer or anybody else for that matter, as to how they would be able to afford the kind of representation they may need in a potentially lengthy process, or in fact the court process. I don't know if Agri-SA have considered that at all. Thank you very much.
Thank you, Tim. Over to you.
I need to indicate that it is the presenters who are bringing the issue of Zimbabwe. It's not me, so just responding to it.
We know that.
Chairperson, I was just having a bit of fun with my colleague, Chairperson.
Thank you. Over to you, Swatley.
Thank you, Chair, and thank you, honourable members, for your questions. Honourable Rai, in response to the question about whether we have considered...
He's always passionate about his surname. Hi.
I do apologise, my pronunciation is poor. Hi. In response to the question about, reference to Zimbabwe and that, it's not specifically Zimbabwe that we're focusing on. It's the result of the erosion of property rights or the security that stands behind that. So if there's a risk that expropriation for no compensation exists and it then scares off foreign investment, it scares off people investing in the country. And that is the knock-on effect that we see in Zimbabwe, Venezuela, and those kind of things. So the focus is really on the property rights that are eroded and the right to own that. And we know that the South African legislature and the government at present have done a lot of homework and a lot of hard work in putting in new legislation that really meets the needs of South Africa. We look at the Land Court Bill, we look at the New Deeds Registries Act. There are a lot of good pieces of legislation that, when read together with the Expropriation Act, will enable our government to do the things that it needs to do. So yes, we do make reference to Zimbabwe, but it's only in the protection of the property rights as far as it goes to nil compensation that it is relevant. Honourable Chair, in response to the question about a counterclaim and whether putting in a counterclaim would resolve any of the concerns we have, I would like to combine that answer with the answer to Tim. I also can't say his surname, so I apologize for that. So in response to that, the counterclaim would in a way resolve a portion of it. Yeah, a person would have an opportunity to put in a counterclaim. However, that could then also be distorted and we'll end up with the same situation. We have people putting in counterclaims for exorbitant amounts of money that don't really reflect the same market value that would be realistic. And it doesn't solve the problem. Coming back to answering Tim's question, we have considered the lopsidedness of the legislation, and we are very concerned, and you'll see in our written submission, that the process that follows, you get the notice, there's a short period of time, even if you get to put in a counterclaim, the land can be expropriated, used for what it's needed for, then you as the expropriated person, whether it be a farm or a piece of land, let's step outside of the scope of land of farming only. You now no longer have an asset or something to generate income from. You now need to challenge that in a court of law. And we find that that process is a little bit flawed and leaves the individual at the risk of not being able to afford the right to go to court and be able to afford that protection of his own rights or her rights. So we do find that that's a little bit lopsided on that side, and if corrected, would allow a more fair process. We understand that if it's in the interests of putting in a railway or putting in a ESCOM lines, it's really important that we get there quickly. If there's a disaster, we understand that as well. But there needs to be a fair process where a third party can approach the court, and the current process in the bill doesn't allow that opportunity. So we'd request that you consider that, maybe give a little bit more fat in it so that we had more time to respond. Yeah. Thank you, Chair.
Thank you, Ms. Buckley, for honoring our appointment. We really appreciate your patience. You have been here with us this morning, and indeed send the message that indeed you take this process of public consultation and hearing very seriously, and we really appreciate that. And indeed, on behalf of the committee, my appreciation to you. Thank you. Honourable members, we will now go to Advocate Paris, DLA Western Cape, representing the First Nation. I think you'll complete that. I'm afraid to misrepresent. Is it the Kwe, the son, or Inga? Inga. Okay. Over to you, Advocate Paris. The floor is yours.
Thank you very much, Chairperson. Thank you very much for the invitation, and we are grateful as the BLA in the Western Cape, as well as on behalf of the First Come Nation, to make oral submissions on the expropriation bill. The BLA has been involved in the Western Cape with land issues, and we assist communities where we can in litigation, advice, and with people who are marginalized in terms of farm working industries and ownership of land. The Aboriginal come for long has been marginalized. They believe, and we stand on the international standard of UNDRIP, that we are the first owners of the land in the Cape Colony, and there's a history. We heard the very first speaker of the day outlining the history of property ownership, the wars, subjugation, and etc. But our oral submissions is confined just to narrow issues. The way we understand this bill, it is not about it favoring land grabs, which was vocalized in this room with fear, with concern, and really negative outlook. This bill is about promoting clean transfer of property in the interest of the public and for use by citizens who are without land and who have been dispossessed. So the first submissions we want to make is at 2.1 in our presentation. And just see here, can this assist me here?
Do you mind if I scroll?
Yes, it's got that. It's the submissions on definitions. And from our experience with matters in court and matters of dispute with legislation, we just like to point out, and I'm sure the drafters and the persons who are assigned to assist the legislature with legislation and the drafting thereof will reconsider the definitions of today, because there's some merit in what many of the speakers before me mentioned, that the definitions are not very clear. We specifically point out the definition of property. We say it should actually be clearer in the bill that property, the definition should read as per section 25(4)(b), property is not limited to land. We would like that inserted. We are also saying, and it would seem from the speaker's submissions before me, some of the thrust of their submissions is they seem to confuse no compensation with no compensation or without compensation. They seem to interchange those words, and when we are looking at definitions, it must be very clear. And we just give an example that often after land disputes and a party is dissatisfied with the result, it often leads to further litigation, and then the whole dispute and the relief and remedy sought is so delayed. And this is not what this bill is about. This bill is about speeding up, streamlining, and fast-tracking land distribution, land reform, and also expropriation. So if the definitions can be more clearer, if the legislature can look at that Clara bill, even though it was struck down by Judge Ngobo in the Constitutional Court, some of the definitions, they were very clear and stood its ground. And so the definition of property there and an amount of compensation was much clearer than this bill. So we are submitting that that be considered. Our next submission is the submission regarding section 12(3)(a) to E. And we agree and we support the bill and the drafters who included the word "but not limited to," because we believe that it should not be a numerous clauses of only certain conditions for when or approach to be followed when considering expropriation. We believe that there are other considerations that may take place. And we list in our submission under 2.4.1, 2.4.2, 2.4.3, right up to 2.4.5, some of those considerations that may play a very important role in determination of disputes or in mediation or negotiation or arbitration with expropriation, in the expropriation process. We say that the actual date of ownership, proper studying of lease agreements of previous landowners and landowners who were awarded ownership by lease agreements, which were transferred maybe by testate succession or by marriage. And then also we say that after the definition of property is clarified, we point to that specifically at 2.4.4, the rights attached to that land should be property, should be in the definition of property. So if there's a parcel of land and mining rights is awarded to the possessor of that land, and that land is a subject of expropriation, there should be a determination on what happens to the mineral rights, what happens to the vegetation, and whether the claimants had indigenous rights.
We must continue with the...
Please, Honourable Chair, can we get people to mute their gadgets?
I think it's better you complete the fact that people
of the nation, they rely, as the former speaker today referred, they rely as far back as 1909 and further before that to the recognition of indigenous peoples and their rights to claim their rights to land and property. And they believe that this should be included in section 25(7), because section 25(7) is not very clear. But a way to remedy that, Chairperson, is that if we say, look, before 1913, as former President Zuma made a submission today, there was dispossession of land. But if we try to apply in bringing this bill in line with the Constitution, if we say that Section 25(8) says, no provision of this section may impede the state from taking legislative and other measures to achieve land water related reform in order to redress the results of past racial discrimination, provided that it's under the law of general application. So for that period, while some people, some groups, right groups will say we are marginalized between the period of 1652 and 1930. Perhaps if the bill can be clearer and saying, in bringing it in line with the Constitution, that this bill respects or is subject to the section of Section 25(8) of the Constitution. And that may remedy that. The fourth submission that we make is that, and it's a very important one because there were many processes like with the expropriation bill and parliamentary sessions, right group making submissions. And then when it reached the Constitutional Court in the decision of Tongoyane and others versus the National Minister for Agriculture and Land Affairs and others, 2009 decision, and the judgment was delivered in 2010 to the dismay of parliament groups, to the legislature, and to groups like Come Nation. Unfortunately, it was struck down due to the fact that there was insufficient consultation with provincial and national structure. So that is something that should also be considered in the bill, and that is why one of the reasons why we also support this bill is because we see that Section 76 is being complied with in this bill. The fifth submission we make is, again, that we feel that there are international conventions, such as in labor law, there's national ILO conventions that support and become the spirit and purport of South African laws in labor. In the expropriation bill, we are submitting that the declaration by the United Nations, which was signed by the South African government in 2016 and committed to, should also receive attention. And the way of doing that is by placing a stronger emphasis on property, the medicinal rights of vegetation and natural plants, which is according to the customary rights of the Kam nation. And some of them are not given that right. In our submission, we refer to an example on page 3, footnote 7. We refer to Professor Jeremy Claessen's submission to the United Nations and abroad and to the national government. He says priority is placed on the development of few medicinal plant species for bioprospecting that are of interest to export companies and benefit individuals from European descent, restricting indigenous peoples as collectors and harvesters plant material. And he refers to be specific, two plants, Galena africana and Expropriation, two plants that may derive wealth if understood by the cultures who know them. That's part of their heritage. And for some reason, this property is not being expropriated in favor of this nation. So in conclusion, we are saying land deprivation, landlessness is the original sins of our people, which our people experience. And this was further exposed by the Freedom Charter in 1955. And coincidentally by a coalition, and that is where it seems like everybody, all political parties across the board are all talking about these days coalition. But it was actually the Freedom Charter in 1955 that brought about this very important document which we all strive for all the peoples of our country. And we just feel as the COM nation that no access to land, neither the land shared among those who work it, often causes lots of prejudice to certain cultural groups who are unrecognized, marginalized, and their leadership not even granted the same respect. And in our submission, lastly, Mr. Chair, we make a comparison between two nations before the Constitution, the Zulu nation and the Kham nation, and to demonstrate the suffering that the Kham nation experiences, the Zulu nation, to some degree, as Nguni and further tribes, managed to establish a trust, a well-known trust, which absorbed many acres of land, hectares of land, which to their credit is now available to their people. To what extent, if the Kham have the same international rights, why are they not given the same opportunities to have ownership of the land that actually belongs to them? Chairperson, just on that issue of your previous questions to other presenters, you spoke about the counter offer, counter claim. Our submission would be that the bill does make provision for offers and counter offers or a counter claim in Chapter 6. If the matter has not reached court yet, if the dispute may be settled by mediation, it says here, if the expropriating authority and a disputing party do not agree on the amount of compensation, they may attempt to settle the dispute by mediation, which must be initiated, and the term that's used, must be initiated and finalized without undue delay by either party. So whether it's the expropriating authority or whether it's the landowner or whether it is the claimant, they all may attempt to settle the dispute, and then it must be initiated. Furthermore, in this mediation or counterclaim, the amount of just and equitable compensation may be determined within 180 days of the time of notice of expropriation. Thank you, Mr. Chair.
Thank you,
Yes.
Advocate Torres, for the manner in which you took us through your presentation. We really appreciate that. I will now open the floor to members. Any clarity seeking questions from the presentation? Honorable Khai.
Thank you, Chair. Okay. And thanks to the yeah. I just want to with regard to the insertion of the amount, the presenter makes a mention of the Clara, where my question would be, is it really necessary to have an amount? What if then the amount depreciates? Because the law that will be making can be there for 10 years and the amount that would be inserted may no longer be having any value in 10 years to come. So is it really necessary to have such? But the next question is on the presenter was quoting section 25(8). I just want to find out whether in his understanding, whether there is any contradiction between section 25(8) or section 25(7) and section 25(8). Would section 25(8) be able to address issues of property before the 1913? Thank you, Chair.
Thank you, Honorable Khai. You're the only one. Over to you, Advocate.
Yes. You want to answer? Okay. Thank you. I was just conferring with my delegation here, and they told me to answer the question. With regard to the interpretation of section 25(7) compared to section 25(8, there is a difference between the two, in that we are saying, they say to the extent provided by an act of parliament, whereas section 25(8 says that the section may impede, no provision of the section may impede from taking legislative or other measures. So these measures may include land reform, because there's a difference between expropriation and land reform. There is a difference, and that's why definitions are important. So both sections are applicable, but to what degree do they coincide when applying it in terms of this bill? That would be my reply to that section. I just couldn't hear the first question properly, Mr. Chair, from the
amount.
Oh, the amount. Yes, I agree. I agree with the honourable member, because this bill provides for instances where in actual fact, the property is actually so disrepair, has not been maintained, and it's even a danger. The act says a danger to other property users, that an amount should not actually be considered. It should be in the public interest to have it expropriated. Then there are other sections, such as if you have a look at section 95A and B, they say the property rates, taxes and levies and charges that are outstanding on the property to municipalities may be so high and in arrears that to an extent that no compensation would maybe be the only outcome in terms of awarding that property to a claimant or to a tribal nation such as Kamka, who can put a plan forward as to how they would work the property with its natural vegetation and water source and etc.
Thank you, Advocate, for those responses. Again, let me express my appreciation for those responses and also for honoring the invite. You are enriching this process, which is quite critical in terms of addressing some of the lacunae that is aimed to be addressed by this bill, because there has been an issue around why has there been no thorough litigation to test the constitutionality of this clauses, particularly Section 25. It was like a no-go area, and to a larger degree, it has created a bit of a burden of the last 30 years. So, yeah, I think it's quite important to appreciate the fact that the idea is to reflect and ensure that the Expropriation Act 63 of 1975, which is a pre-constitutional order, is brought into line. We are infusing the values of our constitution to ensure that it is in compliance with the constitutional principle. From the committee side, we have had views from a whole range of stakeholders, including community organization, the indigenous people, the former president's foundation, academic institution, and also various forums. And clearly, some of the stakeholders have made concrete recommendations in terms of how we move forward, supporting the objects of the bill, while others clear objections to the bill. But it's a continuing journey. Today we could not finish and exhaust our list, and it means we are going to have another round of engagement to accommodate those that we could not take today, and our humble and sincere apology to them, those that were waiting for us throughout the day. The team from the office will again indicate to them the date that we will be having a second round, and it's quite important because on numerous occasions the court has found us wanting in terms of public consultation and public hearing, so we cannot afford to be lambasted again. So indeed, my appreciation, and on behalf of the committee, let me extend a word of gratitude to all the participants, from the members who made it a success for this meeting to take place, our guests for honoring the invite, for enlightening our public and communities about what are the intricacies involved in this expropriation bill, the media, the parliamentary staff, my gratitude to you on behalf of the committee. And indeed, the meeting is now adjourned. Thank you.
Thank you.
Recording stopped.
Thank you, Chair.
Thank you. The excuse.
Thank you.
Thank you very much.